Well, let's get you this update of a young woman accompanied by her father to a photography studio in Bihar's Amarpur, and after taking her picture, the studio owner then allegedly asked her father to wait outside, bolted the door for inside, and tried to sexually assault his daughter. Now, according to the prosecution, he attempted to remove her salwar and physically molest her by pressing her chest. Her screams then alerted her father outside, who then rushed to the door, and the accused thereby fled. The trial court has later convicted him for attempt to rape. But 18 years later, we are looking at this conviction that has now become the center of a fresh national controversy. The case, which has now reached Patna High Court after accused challenged his conviction, where the High Court re-examined the evidence and concluded that the prosecution had failed to establish the offence of attempt to rape. Now, the High Court, however, did not reject the survivor's allegations. In fact, it was accepted that the accused confined the woman inside the studio and attempted to remove her salwar and pressed her against her chest. But yet the court held that these acts amounted to only outraging her modesty under Section 354 of the IPC and not attempt to rape. Now, Justice Purendra Singh held that in the absence of any evidence of penetration, the ingredients that are of attempt to rape are not made out. Now, the court says that there was no medical evidence, the investigating officer was not examined, and that the prosecution rested on testimonies of the survivor and her parents, whereas the Patna High Court order suggested that without medical evidence of penetration, the law cannot recognize as an attempt to rape, which means a survivor who screams loud enough to bring her father running to the door, saving herself from that very penetration, the court now demanded that as evidence, is now being punished for having been saved in time. So the reasoning that has now reached the Supreme Court, where a bench of CJI and others as well were informed about the order during the hearing of a suo motu case that was taken up over the similar Allahabad High Court verdict, grabbing breasts of a minor girl, breaking the string of a pajama, and trying to drag her beneath the culvert would not come under the offence of attempt to rape. Now, senior advocate Shobha Gupta brought the Patna High Court judgment to the bench's attention, where the Supreme Court made it clear that the controversy goes beyond one High Court judgment. Referring to the Patna High Court's observations, the Chief Justice remarked that the judges also have a duty to do proper research before delivering verdicts. In a sharp observation, the CJI said that the staff is doing nothing. The bench said that it would pass a detailed order dealing specifically with the Patna High Court ruling. Unfortunately, this was not one of the cases where law and justice has failed the survivors of sexual crimes. If it is an avoidable pattern now, it seems, because when we speak of the survivor in the case, did she invite trouble? And grabbing the breasts and breaking pajama strings does not amount to rape. That came in from Allahabad High Court in 2025. It was stayed by the Supreme Court. Then 14-year-old consented to sexual abuse. That came in back in 2017 from the Delhi High Court. No POCSO case without skin-to-skin contact. That was something that, remember, had also garnered a lot of controversy. That came in from the Bombay High Court in 2021. Why was she in office at 11 p.m.? Questioning the very survivor, and that was way back in 2013 coming in from the Karnataka High Court. Now the Supreme Court has approved, as we talk about the details that have been coming in, especially when it comes to the Patna High Court ruling and the National Judicial Academy's report when we talk of judicial sensitivity in sexual offensive cases, making its recommendations as a part of a judicial order, where every court in the country has now been directed to follow the expressions and the principles that are now laid in the handbook. Let's in the meantime talk about this development, because the guidelines will now be uploaded on websites of the Supreme Court, all of the high courts and district courts, besides also being circulated to judicial academies and law universities across the country. Let's shift focus now on the urban debate. We also talk about it's been around 13 months, the entire country which is still anxiously waiting to know the reason behind the Air India crash last year on the 12th of June at the Ahmedabad airport. And why did the Air India flight AI-171 to London crash in about 32 seconds after takeoff? Well, this tragedy that left over 260 people dead, coming in from various nationalities, 241 on board and the 19 on the ground. And of course, the crash anniversary this year, the investigative body, which is the AAIB, released a status update report, not the full probe report as it was expected. Now, remember the preliminary report within a month of the crash of what the a paraphrased, a tiny excerpt of the conversation that reportedly happened between the two pilots made many believe that the pilots were at fault. That led to a demand of a full transcript of the conversation that should be released, so that the world knows exactly what happened inside seconds after takeoff, because there are families who are still waiting for closure. Now, amid the long wait, the Aircraft Accident Investigation Bureau has told the Supreme Court that it expects to complete the investigation within 6 weeks, with a final draft report likely to be ready by the month of October. Now, the Supreme Court will also be hearing a batch of petitions seeking an independent probe into the crash, and also ahead of that, an affidavit that was filed in behalf of the Ministry of Civil Aviation and the AAIB. Now, the Aircraft Investigation Board, the AIB, meanwhile, has told the Supreme Court that there is an absolute statutory prohibition when it comes to disclosing cockpit voice recordings and also airborne image recordings from the 12th of June 2025, the Ahmedabad plane crash, to any external committee or even to the public. And here's what their affidavit mentions. The AAIB is of the opinion that when it comes to the declaration, the cockpit voice recordings cannot be shared or cannot be made public, saying that there is a statutory prohibition when it comes to sharing the cockpit recordings. Also saying that the CVR and airborne image recordings are protected, and then this declaration saying that the protection thereafter ensures the witness candor, and also saying that the CVR protection that reserves a no-blame probe process that is necessary to complete the investigation on time. Well, those are the developments that we are now looking at, and of course, when it comes to the AAIB's response, that has now been taken up in the Supreme Court of India. In the meantime, we head into a very short break. Thank you very much for joining me here on The Urban Debate.